Hello, everybody, and welcome to today's webinar. I'm Rob. Thank you to all of you for arriving early, but we will be starting in just about 40 seconds time now. We're just giving everyone a minute to join, and we'll start very soon. Okay, so I think we've got most people that we're expecting now, so we're going to make a start. Welcome, everyone, to this webinar from AIPEX on the Unitary Patent and the Unified Patent Court. Really happy to have everyone join us today. We've got some really interesting information to come up to give you a introduction to the Unitary Patent and all of the changes which could be coming up very soon, and the decisions that patent owners are going to have to make in the next few months. Just a little bit of housekeeping first of all, in that just to notify you that we are recording today's presentation. And that we do want this to be an interactive webinar. We'll have a presentation for you, but then shortly we'll have some Q&A time at the end of the presentation. So if you have a question, please use the chat functionality at the top. You should see, or it might be at the side, depending on what view you have, but you should see a chat bubble where you can type any questions for our team as we go along. So first of all, I'm aware that this might be the first time some of you have come across AIPEX and worked with us. Who are AIPEX? AIPEX is a pan-European law firm with offices all around Europe. We have offices in 11 different countries and are able to provide a one-stop service for your portfolio management and other IP needs. We're made up of 9 different firms who are leading firms in their domestic markets who've come together to form AIPEX as our one-stop pan-European solution. So I'm not going to spend too long on AIPEX because we're here to learn about the Unitary Patent. So if you do want to know more about us, please just reach out to myself or Mark, who's on this presentation as well, and we'll be able to help you with any questions that you would have about AIPEX. But today we're here to talk about the Unitary Patent, and we've got an excellent team from across Europe to help you with that. First of all, we have Elliot, who is from the United Kingdom. He's going to be giving you some information on what the Unitary Patent is. Then Thomas will be joining us from Munich in Germany, where he will be telling us about the UPC and how the court will be set up and how that will work. Then we have Philippe, who is in Lyon in France, who will be telling us about some of the cost implications. And then Kees from the Netherlands, who will help us with some of the many questions that we're getting at AIPEX around this, so we'll help answer some of those practical questions for you. You may see behind me that I've got Hungary here. I'm in Budapest here today, visiting our Hungary office. I'm actually, as you probably guessed from the accent, actually British and based in London, but very happy to be able to get around all of the AIPEX members and today here in Budapest. So that's enough from me, and with that I will pass over to Elliot. Elliot, over to you.
Thank you very much, Rob, and good morning or good afternoon, everyone, depending on where you are. So today we'll be giving a presentation on probably the biggest and most dramatic change to the European patent landscape for over a generation. And of course, I'm referring here to the introduction of the Unitary Patent and the Unified Patent Court. However, before we discuss these changes, we thought it would be useful to discuss the current mechanisms for obtaining patent protection in Europe to give some perspective to the changes taking place. Okay, so first let's discuss the current options for securing patent protection across Europe. And on this map, you can see on this slide a map of Europe with various countries indicated with their national flag. Now, as you know, patents are territorial. So a UK patent, for example, only enables the proprietor to control the exploitation of the invention in the UK. So if you want protection across a number of different countries, it's necessary to obtain national patents in those countries. And the most basic means of obtaining the national patents is by filing a patent application in the countries of interest. Now, from a practical point of view, each national application will require the appointment of a local attorney, the payment of separate national fees, and also the translation of various documents. So this is quite an intensive process, and it requires careful coordination, and it can be quite expensive. However, once the national patents have been obtained, they can then be enforced, and this is done at the national level via the national courts. So if you want to take action against an infringer in Germany, for example, it would be necessary to enforce your German patent in the German courts. Similarly, if you or a third party wanted to invalidate a national patent, then it would be necessary to do this at the national level. Now, the 1970s saw the introduction of the European Patent Convention, and with it, an alternative mechanism for securing patent protection in Europe. This convention established the European Patent Office, and with it, what we know today as the European Patent Application. Now, the European application enables applicants to file a single application that covers a number of European states in one go. Now, it's important to note here that the member states of the convention are not the same as the member states of the European Union. In fact, the European Union states are a subset of the convention states, and these states are represented in red on this map. Now, European applications are examined centrally at the European Patent Office, and once any objections have been overcome, the application will proceed to grant. The European application thus enables applicants to obtain a patent covering a number of states with only a single application procedure in one language and with a single set of official fee payments. So as you can see, the European application is much more cost effective in obtaining patent protection in Europe compared with filing and prosecuting separate national patents. However, there's always a catch, and once a European application grants, it's then necessary to select those states in which the European patent is to be made effective, and this is known as the validation stage. Now, the validation process is different depending on the particular state, but it can also involve submitting a translation of the granted patent into the local language. So again, there can be a significant translation charge after a European application is granted in order to make the patent effective. Now, once the validation stage is complete, the single European patent will then become a bundle of national patents, each of which is a standalone patent, just as if it had been obtained via the national filing procedure. And any proprietor wishing to enforce their national patent is then required to do so via the national courts, just like before. And similarly, each national patent can only be attacked at the national level. So as you can see, the European application offers a benefit in obtaining a granted patent, but then post-grant, the procedure for enforcement and validity is largely the same as if the national patents were obtained via the national route. Okay, so with this backdrop, let's now consider the new Unitary Patent. So the first thing to say is that the Unitary Patent is only obtainable via an existing European patent application. If you have a European application pending at the time the Unitary Patent system enters into force, then you have the option of requesting unitary effect, or what we call a Unitary Patent. Now, the Unitary Patent system is expected to come into force in early 2023. So if you have a European application pending at that time, you'll have the option of selecting a Unitary Patent. Another point to note is that a Unitary Patent can only cover European Union states. And at the moment, This includes 17 of the possible 24 European Union states, and these are shown in dark blue on this map. Now, it's currently 17 because only 17 European Union states have ratified the Unitary Patent System, and there is only a maximum of 24 possible states because Spain, Poland, and Croatia are not taking part. So to access a unitary patent, as I mentioned, it's only available via the European application process, and particularly only once the European application is granted. So the unitary patent is obtained via the validation process. And instead of having to make a European patent effective in, say, 17 states, you will have the option of selecting a unitary patent where you can cover a new pseudo-region of these 17 states in one go. So for all those other states which are part of the European Convention, such as the UK, it would be necessary to follow the classical validation process to obtain the national patent. Now, just to be clear here, you're not required to select a unitary patent, and the classical national patents obtained via the traditional validation process is still an option. If you only want protection in Germany and France, for example, then you can simply validate the European patent in those states and not bother with the unitary patent. So as you can see, going forward, a European patent may give rise to a bundle of national patents and a unitary patent covering a region of 17 states. Now, the unitary patent can then be enforced in a particular member state, and that decision will become effective in all member states. So there is no need to conduct simultaneous proceedings in each member state. For example, a decision that the unitary patent has been infringed in France will also be binding in other member states like Germany and Italy without the need to conduct separate proceedings in those countries. So what do you need to do to get a European patent, a unitary patent? Now, as I mentioned, it's only available via the European application process and as part of the validation stage. And this process is administered by the European Patent Office. So once your European application is granted, the traditional validation deadline for making a European patent effective is 3 months from the grant date. However, for a unitary patent, the validation deadline is shortened to only 1 month. So decisions will need to be made quickly. So there's no official fee associated with making a request for unitary effect. All we're required to do is submit a form to the European Patent Office, and this must be accompanied by a translation of the European patent into another EU language. However, this can be a machine translation, for example. Also, just from a practical point, the claims of the European application as granted must be identical for all member states of the unitary patent. This is to ensure the unitary patent has the same unitary effect across all states. Now, over time, as more states ratified the unitary patent system or the agreement, the territorial coverage of the unitary patent will grow. And so there will be different generations of unitary patent going forward, but it's important to note that the territorial coverage of unitary patents which have already been obtained will not be extended as new states join. The states covered by a unitary patent will be fixed at the time the European patent application grants. So just to give a little real-life example, if an applicant of a European patent application would like to extend their protection to, let's say, for example, UK, Germany, France, Italy, and Spain, then once the application grants, the proprietor would be required to validate the European patent in each state separately within 3 months of the grant of the European application. As I mentioned before, this can involve submitting translations of the patent into the local language, and it will also require the ongoing payment of separate renewal fees to each national office to keep the patent in force. But the end result is the European patent would give rise to 5 separate national patents. However, once the Unitary Patent System enters into force, proprietors will have the option, or the further option, for covering the 5 states with a unitary patent. So, for example, proprietors would still need to use the classical validation process to cover the UK and Spain, as these states are not part of the Unitary Patent System, but proprietors can choose to cover Germany, France, and Italy, and indeed, by virtue of the Unitary Patent, the other 14 member states, with a single request, a single unitary request for the Unitary Patent. And this will therefore avoid having to file separate national validations in Germany, France, and Italy. So there's some considerations needed as to the pros and cons of whether the unitary patent may be suitable for you. And to provide some further insight into the unitary patent and for an introduction to the Unified Patent Court, I'll hand you over now to my learned friend, Thomas. Over to you, Thomas.
Thank you, Elliot. So we do not even get a new court. Just a second. Yeah. So we do not even get a new patent system with the unified patents. We also get a new patent court system, which means that with this new court system, all the unified patents can be enforced or invalidated. So those new, I'm sorry, the control is not working as it should. The unified patent courts, we have a central chamber in Paris and in Munich, but we also have local chambers located in almost all of the member states, up to 4 local chambers, for example, in Germany. And the judges which are at the moment hired for the Unified Patent Court are, let's say, international judges, which means they have a lot of experience at their local courts. And there are even some technical judges in those chambers. So we expect that the quality of the Unified Patent Court is increased to the national patent courts, infringement courts, because usually there are no technicians sitting at those courts. If you are successful with your infringement suit, you will be able to enforce the favorable decision within all 17 member states. So what is interesting from a German perspective, Germany and, for example, Austria, we have a so-called bifurcated system, which means the infringement cases are handled by a court which is different to the court for the validity situation. So you need 2 successful decisions on infringement and on validity by different courts. In contrast thereto, the Unified Patent Court now is one court which handles both. The US attorneys of you know that this kind of your system, that both is handled in one proceeding. So if I'm attacking an infringer, the attacked infringer will argue the patent is invalid, and all this is handled by the Unified Patent Court. On the other hand, there is and from my perspective, that the largest drawback of the Unified Patent System is that now your Unified Patent can also be, on the other way around, nullified by one single attack. And Philippe will explain to you how expensive that is. And I can already say that is on low cost, you can attack a unified patent. So the risk for the patentee is higher. For example, you have an infringer and he's really not really happy with your patents. He may be already starting to make searches in order to attack your patents as soon as they are granted. So this is really a certain drawback of the Unified Patent Court. There is, now it comes to the probably the most difficult part of the Unified Patent Court and its system, because you would expect that the Unified Patent Court is, of course, responsible for the unified patents, but it is also responsible for the classic, existing, and future EP patents. So if you are not willing to have a unified patent, you're at the European Patent Office, but you like the classic system, you may, or the Unified Patent Court can take over the responsibility for those classic EP patents. There is a transitional period of at least 7 years, and during this 7 years, the Unified Patent Court is parallel to the national courts responsible for your classic European patents. And this is very, very surprising. The patentee can decide whether he wants to attack the infringer at a national court or at the Unified Patent Court. As soon as he has taken this decision, then he's fixed to this court system. So if I have a first infringer and I'm saying I have good experiences with the German courts, I know them have them known for years. I'm starting with for example, with a Düsseldorf lawsuit, and later on I have a second infringer. I'm sticking on the national court system. I don't have to sue him in Düsseldorf. I can also sue him anywhere, but it's in the national court system and not the Unified Patent Court. Other way around, if I like the Unified Patent Court, I like to try it out, then I will remain with the Unified Patent Court for this classic European patent. After the end of this transitional period, however, the Unified Patent Court is only responsible for your classic EP patents and not the national patent courts anymore. There is one exception. The exception is a so-called opt-out declaration, which you can declare, which you can file within the transitional period. And if you have filed that, you will be able to handle all your EP patent with the national patent courts. We need an example, I think, to clarify this difficult situation. You have an existing EP patent for these 5 countries. Your first option is that you are using national courts, and of course, the outcome can be different decision depending on the court or on the judges. You may say this is a drawback. I'm saying it can be an advantage. Perhaps I'm not successful with my lovely Düsseldorf court. I have lost the proceedings, so why should I start in Milano? No problem, or in Paris, so I have a second or third chance. So this is the advantage of the national system. The second option with my classic EP patent is that I'm using the Unified Patent Court for suing my infringer, and my final decision would be valid for the 3 states which are member states of the Unified Patent System, and for the remaining 2 states, Spain and Great Britain, I need national decisions. Now, coming from the side of the infringer, the nullity suit, which is important for me. I hate this patent. It's a pain in the neck. I may start a nullity suit at the Unified Patent Court in order to have the 3 countries invalidated, France, Germany, and Italy. But for the remaining countries, I need separate decisions, which means I have to go to Spain and separately to Great Britain. As already announced, there is one option for you, and this option will be very important. The opt-out declaration for your existing classic EP patents or upcoming EP patents. If you declare that you are not willing to take the chance to go to the UPC, Unified Patent Court, and are happy with the national court system, you are able to file the opt-out declaration within the time limit of 7 years, and then you are bound to the national courts. This declaration can once be withdrawn. Let's make an example. I know I have a weak patent, and therefore this central attack is a little bit risky for me. Then I'm opting out to have all handled at national courts, and provided that there are no national attacks and I'm not attacking someone on a national route, I can opt in again once, not opt out again. So this would be the result of the opt-out. All countries are only on a national route enforceable. So you're summarizing your options are for your classic EP patents, you can opt out. If you want to save your patent or you think it's a weak patent, opt out as soon as possible. That's the first option. The other option is to wait and then finally decide whether I would like to enforce or attack a patent before the UPC or on the national route. So you have both options still open. The question is, of course, drawbacks and advantages are how cost intensive will the Unified Patent Court be? This might be very decisive for you. And Philippe is a specialist on costs, and he will take over this role to present the costs of the UPC and the Unified Patent.
Thank you, Thomas. Now we will discuss some questions regarding the costs of the Unitary Patent and the Unified Patent Court. And we'll discuss that with regards to examination, validation, maintenance, and litigation. And I think this is important because one of the reasons to introduce this new system was to reduce the amount of euros that was spent, especially on validation. So let's see how we can, what we expect can be the results. So let's talk about examination costs to start with. As Elliot said before, this is pretty much the same examination for the European patent application, whether you want to get a classic European patent or a unitary patent. So the costs will be identical for in both cases. Also, as Elliot mentioned, there will be no official fee for requesting the unitary effect. So for examination, there is no difference between a classical European patent or a unitary patent. Now, let's turn to validation and maintenance costs. Of course, and Elliot said as well, there are no validations for unitary patent. Still, we need to take a look at validation costs because also, as Elliot said, some countries from the European zone are not part of the unitary patent. So we'll need to compare where we still need to make validation and we don't have this unitary patent. Concerning annual fees, there will be one annual fee to be paid centrally for unitary patent, which is roughly equivalent to what has been paid for 4 validation states. But there's also something that you need to take into account concerning annuity fees. The unitary patent is a package where you can't just abandon one of the countries. So you can't do what you were doing before, like abandoning some of the country parts of the unitary patent. You will take everything as a package from the day where it's granted until you fully abandon it. So it's not easy to give like one solution or one idea about whether it's going to be more cost effective to use the unitary patent or the classical EP patent. So what we'll do is we'll take examples depending on the choice of countries you have, and then we'll see how the two options would compare. So the first example is an example where you have 10 countries. If you would be in the situation, which is the situation today, after the grant of the European patent, let's say about 4 years after filing, more or less, this is what the hypothesis we took, you would need to validate in 10 states. Here we chose Germany, France, UK, Italy, Spain, Belgium, Turkey, the Netherlands, Switzerland, and Sweden. Now you have another option, which is to use the unitary patent. And as Elliot explained, there are some countries that will be in the unitary patent. Here, Germany, France, Italy, Belgium, the Netherlands, and Sweden. But you will also have countries that are not in the unitary patent, and therefore you need to still validate in those countries with the classical EP patents to get protection. So in that case, you would still need to validate in the UK, Spain, Turkey, and Switzerland. So in this situation, so we've compared the two options without the unitary patent or with the unitary patent plus additional classical EP patents. In this case, it looks like the solution with unitary patent plus extra classical EP patents is actually cheaper than the solution with only the classical EP patents. So, well, this is the first example which is more in favor of the unitary patent in terms of costs, because this is a relatively large number of countries. What you need to see here is that, as Elliot said, there is also a difference in the geographical scope of protection, because with the classical option, you just get 10 states and that's all. With the unitary patent plus classical EP patents in the remaining states, you get actually a protection within 21 states, the 17 states of the unitary patent, plus the 4 additional states that you've added. Here it's UK, Spain, Turkey, and Switzerland. So it's not the same geographical scope. Let's take another example where you have less countries. And here only 6, Germany, France, UK, Italy, Spain, and Belgium. Here, if you take the protection via the classical EP patents, you would just validate in 6 states. If you take the route using the unitary patent plus additional classical EP states in the UK and Spain, then you would get a protection in 19 states. So again, there is a distortion in the geographical scope of protection. In this case, it looks like it's pretty much the same cost after 20 years for both options. However, you can see that it's slightly cheaper with the unitary patent for, let's say, the first 15 years, and then it's pretty much the same at the end, because mostly because the annual fees for unitary patent is not very expensive for the first years. But also you lose the option with the unitary patent of getting rid of some of the countries before. But still, we're pretty much even on this example. Now I have a third example, which is with a more limited number of countries. Here we just have, with the classical patents, we would just want to choose Germany, France, and the UK, which is a pretty common choice for some of the applicants. In this situation, and I think you can expect that, it's actually cheaper to choose the classical EP patent where you just validate in those 2 countries, especially because you don't have to file actually translation in those countries. But you could also try to choose the unitary patent, and then in this case, this unitary patent would cover Germany and France, and you would need an extra a classical EP patent to cover the United Kingdom. And as you could expect, in this case, the classical EP route would be much cheaper than the route using the unitary patent plus an EP patent for the United Kingdom. Again, the geographical scope is difficult to compare, because in one solution with a classical EP patent, you would just get protection in 3 states. And with the unitary patent, you would get actually protection in 18 states, just 17 unitary patent states plus the United Kingdom. Now let's talk about the cost of the Unified Patent Court. There are things that we need to take into account to calculate those costs. And first thing is the court costs. the cost and the way it's calculated is pretty much inspired by the German system, where you have a fixed fee plus a value fee that depends on the amount in dispute, which is common also, which is the case also in the German system. However, this is for infringement proceedings, and for invalidity proceedings, you would have just a lump sum to be paid. Well, the second court instances has also court costs that are calculated in the same way. Concerning the attorney fees, it has to we need to take into account that the timing of the proceedings before the UPC will be very concentrated in time, and we expect that there will be 12 to 14 months for a first instance or a second instance. So this means that a pretty large team of attorneys may be involved, and we therefore expect that there will be a relatively high amount of attorney fees to be spent on before the UPC. Also, to say a word about the reimbursable costs, the upper limit also depends on the amount in dispute, and the court might decide whether to do with this upper limit, whether they grant less or if they grant a bit more. Now we have just this slide. Maybe it's not, we won't get into much details, but it's just to give you an idea, because it's not common for everyone to have costs that are calculated based on the amount in dispute, but just to show that let's say the green lines are for the calculation of the court costs for the German proceedings in infringement or in invalidity, and the blue lines are for the UPC court costs in infringement and invalidity. And it appears that the court costs are lower than what you have in the German case. And for reimbursement, this is the right-hand side of the chart here. You would see that you have higher reimbursement of cost than what you could expect in Germany. And so the cost estimates for litigation, we're not going to get into much details here, but we try to summarize some of the ideas. And of course, it's very difficult to give precise numbers because it's very different from one case to another. But so the amounts that are to be spent usually in Germany, France, and Netherlands are pretty much the same, or let's say in the same range. But we expect that the amounts before the UPC will be higher than a litigation before one of those courts, and maybe in the range of one or two of the litigation before the other courts. We put the figures for the United Kingdom on the side here, but because the UPC will not concern what's happening in the United Kingdom, so you still need to think about what you want to do in this country. So it's going to be still something which is apart from what's happening before the UPC. So to summarize about the cost implications of the Unified Patent and the Unitary Patent and the Unified Patent Courts, the examination costs will be identical before the European Patent and Unitary Patent. Concerning the validation and maintenance costs, it's pretty difficult to compare. However, and the best option might depend on the number of countries of interest and if said countries are in the UP or not. We have a cost calculator on the AIPEX website to give you and to allow you to compare in your specific situation what is the best solution. It's usually better to use the Unitary Patent if you want to have a broader scope of protection. Now, concerning the litigation costs, as we said before, the cost will probably be higher before the UPC than before one or two national courts. But as Thomas said before, you may get a decision which might be enforced in several countries with the danger of getting the revocation, as Thomas explained as well. And I will now leave it back to Rob.
Actually, Case that we're going to yet. So,
oh, sorry.
Case, all right.
Sorry, Case. So it's Case now.
Yeah, the small countries are being ignored again.
Oh, sorry.
So, as you can see now. Yeah, thanks, Philippe, for the introduction. Yeah, a warm welcome from the country of windmills here. I do have a bit of a cold, so I hope you can hear me clearly. It's probably because of having lived in these windmills, which are cold and dusty for too long. What I'll be discussing with you is some practical questions and answers from our client perspective, which is also meant as a bit of a wrap up of the preceding parts. So yeah, first question. Yeah, a clear one. Can you give us a timeline of the UPC? Yeah, from the last rumors, they say that the 1st of March of 2023 will really be the start of the UPC, and that also means that the sunrise period preceding the UPC will start on the 1st of December. So that comes pretty quickly. And we're basically now in the left arrow, the provisional period. So some more questions about opting in and opting out. That's really where the importance for you lies for making choices with respect to your patent portfolio. So yeah, the question we received from a client, why is there a transitional period anyway? Yeah, as discussed before by Elliot and by Thomas, yeah, it will be possible to start litigation in a national court instead of in the Unified Patent Court, initially for 7 years, and that may be extended to 14 years even. Yeah, during this transitional period, you'll be able to opt out of the unified system to ensure that proceedings can only be brought in the national courts. And as discussed before, patents which have been opted out will stay opted out for the whole term, unless the patentee withdraws the opt-out, which they can basically do at any time. So yeah, if opting in is default, so there's no need to file a request for a unitary patent then. Yeah, as mentioned, opt-out is a means by which a patent owner can remove patents and patent applications after publication from the jurisdiction of the UPC. And the default position indeed is that all European patents and applications with a filing date of the 1st of March 2007 or later will be subject to the jurisdiction of the UPC unless an opt-out is filed. And it's important to note that an opt-out is related to the Unified Patent Court and not so much relevant to unitary patents, because yeah, European patents as such are always subject to the jurisdiction of the UPC and yeah, cannot be opted out logically. So yeah, another question, how can I see that my patent is opted out? Will this be published? Yeah, there will be a register for unitary patent protection, which will be actually a new register as an integrated part of the existing patent register. And it will show where the unitary effect has been registered for a European patent and provide information concerning any proceedings before the UPC. Yeah, it's important to note, I put it as a note here, that the registry basically does not check if declarations at the time of filing are correct. So if they appear to be wrong later on, an action can still be brought at the Unified Patent Court, and the opt-out basically has no effect. That's important to note. And for example, if I file a divisional application, can the parent application be opted in and can the divisional be opted out? Yeah, in principle, that's possible. Some people even suggest this to test the system. However, there may be double patenting provisions in some of the nations concerned, although the UPC agreement itself does not really have provisions, if I'm correct, about double patenting. And yeah, you could also consider having national utility models filed. So another issue that's important, what if I co-own a patent with another person or another entity? Yeah, in that case, it's important that the consent of all the co-owners is required to perform the opt-out. And as I said before, the registry does not really check if the declarations are correct. So if an opt-out is later to be found incorrect, then it has no effect at all. And you can also maybe see yourself that one of the declarations is incorrect and have it corrected, but then the opt-out will only have effect when the correction has been implemented. So yeah, good question. So what invention should be opted in or opted out? Do you have any guidelines for this? Yeah, basically, I think Philippe already mentioned this in his presentation. Inventions not critical for your business or strong inventions in terms of patentability, novelty, inventive step may be opted in to test the system. but inventions critical to your business or weak inventions or inventions subject to licensing agreements may be opted out. So yeah, this is mainly about prosecution. If I opt in, can the same attorneys be working on my case? Yes, in principle they can. When they are European patent attorneys, they have the right expertise to advise you on the UP2. So some questions surrounding grant. Yeah, so about translations. What is the term for filing a translation when I file for a unitary patent, and what sort of translation should that be? Yeah, during the transitional period, the translation of the whole specification is required. If the patent is written in English, then the request must be accompanied by a full translation into any other official language of the EU. That's important to note. So, for example, the Netherlands being an important country, you can file your specification in Dutch if you like, or in Greek or whatever language of the EU you would like to have. But if the patent is written in French or German, then the request must be accompanied by a full translation of the specification into English. And the translation, I think that has been discussed before, it must be submitted within a month following the decision to grant, together with the request for a unitary effect. So another question that was asked, a request for a unitary patent can be filed for granted patents, but what if my patent just got granted before the unitary patent becomes available? Yeah, so as we discussed with respect to the previous slide, there's a period of 1 month from grant in which to file a request with the EPO that the patent has to have a unitary effect. The EPO will implement 2 measures to facilitate the request for unitary effect for those patents that are granted close to the entry into force of the unitary patent system. And these 2 measures are an early request for unitary effect and a request for basically delay of the grant. So some questions about a grant, and now a bit about after grant. This also touches a bit on what Philippe has discussed with respect to cost. So yeah, when is a unitary patent interesting from a renewal cost perspective? Yeah, the annual fees are roughly equivalent to what has to be paid for classical validation states. I think Germany, France, Netherlands, and UK served as a guideline for this. And yes, as Philippe also discussed, it's not possible to drop individual patents as you may have done with classical EP patents. And so you cannot reduce the cost for renewal fees towards the end of the patent term. And a bit about after grant. Yeah, so a question we received about the organizational structure of the UPC, and this has also been briefly discussed already. There'll be 3 institutions: the Court of First Instance, the Court of Appeal, and the Registry. Letter 2 will be based in Luxembourg. The Court of First Instance will be the most important one, which is competent for instance, patent infringement proceedings. Yeah, there will be central divisions as discussed in Paris, Munich, and the other one is still open, I believe. I think Milan is a good candidate for this. And then local and regional divisions can be set up for each contracting states upon request. And basically the competency between the divisions is divided based on the patent classifications of the WIPO. So who may bring actions before the Unified Patent Court? Basically everybody, natural persons and legal entities. Yeah, the proprietor of a unitary patent, but also exclusive licensees. They may bring infringement actions, although the proprietor should be informed of this. And also non-exclusive licensees are allowed to bring actions before the Unified Patent Court if the license agreement allows for it. And actions for revocation may be started by anyone in principle. So yeah, these were just some sample questions we received. That there's probably many more questions to be asked, because this does not cover the whole span of questions that can be asked, and that's for the Q&A session that's to start now. Rob, back to you.
Excellent. Thank you very much, Kees, and to all of you gents for some great presentation there. Really good level of knowledge that we now have on that. But we do have some questions coming in. We've got about 10 minutes, so apologies if we don't get to all of your questions, but I did want to pick on a couple of these just to reinforce things. I think if we go back to the beginning or not quite the beginning, but if we go to Thomas's section on the UPC. Thomas has a question here from Krishna. Will the different patent courts not have different interpretation for the patents?
Yes, that may happen. You can't avoid that. There are people behind that, and the judges should be people and humans. So there will be, of course, different opinions on that. No question on that. There should be a harmonization. I think the harmonization between the local courts and the central chamber will be better, of course, better than with the national courts, because those judges are meeting and it's decisive for them that there is an harmonization. So there will be programs in order to exchange decisions, views of the judges, but the decisions itself are done by the courts, and there are not decisions between all the courts. So a court cannot say, I'm uncertain, I will ask the Milano court and would like to get some help. So yes, there could be some different questions. And I may also shortly answer to Luis Alfonso's question on the translation. Yes, you're right, paragraph 12 of the regulations say something about machine translation, but it says that the machine, it should not be machine translated, which is not a must. It has to be machine translated. So the background is the translation which you are filing should be on a certain quality, and I can only recommend to you deepl.com. This machine translation is worldwide the best, much better than Google Translate. So if you're filing a DeepL translation, you will indeed have filed a better translation than with the Google. So don't fear about the machine translation at that point.
Also, we can say that the same regulation says in Article 6.2 there is no legal effect of this translation, yeah. So you should be fine.
Yeah.
Excellent, great. Thank you both. I should say, while I'm talking, apologies if there's any background noise. I seem to have brought the British weather here to Hungary, and there's a rainstorm happening outside, so banging on the window. So apologies if there's any background noise. But I did have another question to go back to Britain, actually, for Elliot. So is there a limit on how long you can delay a grant in the lead up to the start of the UP system?
Sorry, just trying to find my microphone button.
Okay.
So the opportunity to delay grant is only available really during the sunrise period, and only for those European applications which have received a notice of acceptance. So if you received a notice of acceptance and you haven't replied, but the deadline falls within the sunrise period, you can file a request at the European office to delay the grant to give you the opportunity to access the Unitary Patent system once the application grants. Now, there is no limit, as far as I'm aware, to how long that delay will last. I believe the European office will withhold granting the European application until the Unitary Patent system has come into effect. As a separate point to that, I would also add that as well as delaying grant during this sunrise period, you could also file an early request for unitary effect. So you could get your request in early as well if you wanted during this sunrise period, so that you have an opportunity to select this unitary patent when it kicks in.
Perfect. Thank you, Elliot. For our next question, I'm going to go to a question that came in case during your part of the presentation, and a particular date that you gave. The date of the 1st of March 2007 for EP subjective to the UPC. Where does that come from, that date?
Yeah, it's a good question, and actually I don't know. I did not draft the UPC agreement. Yeah, just to guess, it may have to do maybe with the EPC 2000 that came into effect around this date. But to be honest, I'm not completely sure.
Okay, no problem. Good. Let's go back to Thomas for another UPC question. When you say that the UPC gets jurisdiction over EP patents as well, this means that the EP patent in as far as the UP states, is that correct?
The EP states, the states in which your classic EP patent is validated or will be validated. So only you're limiting it, of course, to the countries which you like. And if you are validating only in 2 countries, the UPC is the responsible court for these 2 countries. The others are not selected by you.
Okay, great. So you guys have really efficiently answered the questions. There's just one more which I'll answer in a moment, actually. But while I do that, if anyone else has any other questions, we do still have 5 minutes left in the webinar. So please feel free to ask any other questions. But if the guys have answered every question that you could possibly ever have on the UP, then we'll give you some time back in your day. But so the last question that we did get there was further to Mr. Kitzhofer's answer. Is there a link to the preferred translator on the AIPEX website? Not currently, but we'll look into that, and we'll get that, and maybe we'll mail that to all of you who are on this webinar as well, so that you can have a copy of that. What is on the AIPEX website was what Philippe mentioned earlier. He mentioned a couple of times the cost calculator. So if you do want to understand what this means for your portfolio, if there's certain countries that you almost always register your patents in, then do feel free to head over to the AIPEX website to the cost calculator, and you can plug your information in there and have a look and see what the cost implications are. Okay, any other questions? You have about 10 seconds to come in. Otherwise, I'm going to wrap up. And say thank you very much to our presenters today. Thank you very much to our audience. It's been a pleasure to host you today on this AIPEX webinar. If you do have any other questions, because I'm aware some questions are more specific to your unique situation, so maybe today wasn't the right time to ask them. So feel free to get in touch with us, and we'll be happy to talk you through and give you some pointers in as far as your particular unique portfolio needs are, and happy to talk through that. Our contact details are here, or you can contact myself, Rob Davey. So that's rob.davey@aipex.eu. Mark is here as well, so you can also contact him. So very happy that we were all able to be here today, and thank you very much for so many of you turning up, and we will be in touch and maybe have a more advanced webinar once we get closer to the time, and we can give you some more targeted information on what's happening as far as the UP launch is concerned. So thank you very much.
Thank you.
Thanks all.